All right. Hey, everyone. Brian Bogner along with Justin Hamrick here. Thank you so much for logging in here to this presentation about estate planning. I see names popping in here as we've opened the webinar up. We're going to be talking about estate planning, creating, protecting your legacy, especially here in a COVID world that we're living in right now. So there's still more folks joining in. I'm just giving it here just a few more seconds here as I see some more folks popping in here. But let's go ahead. Yeah, we'll go ahead and get started. I'm Brian Bogner. I'm a financial planner here in Greenville, South Carolina with a firm called Parallel Financial. I've been doing this for about 20 years now. We help families basically make wise financial decisions so they can live the life they want. We've got an office here in Greenville, Spartanburg, and Seneca. And I'll let my partner here, Justin, introduce himself.
And as Brian said, my name is Justin Hamrick. I'm an attorney in Greenville, South Carolina. Been practicing for about 10 years now. The vast majority of my practice is devoted to estate planning, helping people plan for incapacity, death, and then once they pass away, wrap things up. And very happy to be on the call today.
Yeah, and we're here just like it says here on the slide because we have seen too many people not plan, and the result being needless distress and needless money spent on things that should have never happened if there was just some planning done. So you're here to also learn about that. So let's go ahead and dive right in. If there was ever a time to get your affairs in order, we would say now is the time. I mean, these are just some stats. These were updated, I think, yesterday. 2.2 million people in the United States with COVID, almost 120,000 deaths. Thankfully, though, we're 733 recovered so far, 733,000. So there's some good things there. But the reality is, no one is immune to this virus. And making this difficult right now are the stay-at-home orders that in some areas are being lifted, some areas still there, some areas they're kind of coming back again, but people have been isolated from their families. I live 20 minutes from my parents. My dad's 82 years old, and I've had for a couple months, I didn't even see him. Recently, we go over and sit out on the porch and just kind of, because he is kind of the prime case of who you do not want to get this disease. And so quarantine, isolation, and if you're isolated and you go to the hospital, right, you're whisked away into the ER and ICU. Your family can't go in and be with you and support you during that time. They have to be separated, okay? If, because of isolation, if you need to be put on a ventilator or something like that, you can't speak, for yourself. Your spouses or your children or your loved ones aren't standing right there to speak for you. So this has created a lot of issues here, very unique, that we've not had to deal with before. So that's why we're here. We're going to talk about planning. What can go wrong, however, if you don't plan? I think it's important we cover this. Well, first of all, the state of South Carolina decides who inherits your assets. No fun there. You may owe additional taxes on your estate. Your family likely will have to get court permission to act on your behalf, which is no fun going through either, especially during a tough time. You may not be able to be with your family and loved ones if something happens to you, and that could result in inappropriate medical and financial decisions. So today we're going to cover the 3 stages of estate planning. Incapacity, meaning how will someone be able to care for you on your behalf, especially in light of COVID-19, if you encounter some type of bad event. Secondly, at your passing, how will your assets actually be transferred at your passing, in terms of probate and things like that. And then third, we're going to be covering asset distribution, meaning once those assets are how are you going to leave your estate to your spouses and your loved ones, all right? But I want to tell you, please stay to the end. This presentation is only about 30 minutes long, okay? And we will do some Q&A at the end, but stay to the end because we're going to talk specifically about some COVID-19 updates, especially around healthcare planning. We're also going to talk a little bit about the Secure Act and some IRA tax changes that we're kind of adding to this as well. We've got a giveaway that I'm going to explain a little bit later, where we're going to be offering a 30-minute estate checkup where for those that are in this call, if you want to talk specifically about your situation, Justin and I are going to be available this week. I'll go over a little bit of that at the end there, and we're also going to do some Q&A. One thing I do want to give away to you right now, if you're sitting at your computer, which you probably are watching this, if you email me right now, and this is my email address, brian@parallelfinancial.com. I'm going to put it in the comments as well, or excuse me, in the chat box as well, typing it in here. And you just put toolbox in the subject line. We're going to give you 3 things. We're going to give you the Family Guide to Savvy Generational Planning, 6 tips for organizing your records, and 14 items to include in your will. So if you want those 3 things, that's all you got to do. You can do that right now, or you can do it after the call, whenever. All right, so let's go ahead and get started. Justin, I'm going to go ahead and turn it over to you here to get going.
Thanks, Brian. A lot of people think estate planning is just about death, but it's far more. It's far more about death than you might think. Incapacity is a big factor. Most people don't just drop dead. Most people go through some period of incapacity at some point in their lives. And if you're incapacitated, you need someone to have the authority to be able to make decisions for you. Decisions related to financial and miscellaneous issues, as well as healthcare decisions. So let's talk about financial and miscellaneous issues first. At the very least, you're going to need what's called a general power of attorney, or abbreviated, I call it a general POA. And it's a document that authorizes a certain person to be able to access your bank accounts, to use your money for you, to buy on your behalf, to sell on your behalf, invest on your behalf, deal with retirement plans, governmental benefits, and many more things. And if you do not have this document in place and you become incapacitated, it's very likely that your family will have to go to court to get permission from a judge to be able to do these things for you. Not only is that very time consuming for your family, but it's also really expensive. Now, many people already have a general POA in place, but there can be some drawbacks to relying solely on a general power of attorney for incapacity planning. And this is something that is not discussed much, even by many estate planning attorneys. The example I like to give is, let's say that your mind starts to go at some point. People are calling, schools, charities, churches, asking for money, and you're giving money away to anyone who calls. You still think you're with it, that you have capacity. The rest of your family realizes that you don't know what you're doing. How do they stop you? They've got to take you to probate court and get a judge to basically strip you of your rights to that money. Not only is that process, again, time consuming, it's also expensive. So how do we get around this problem? There what's called a revocable trust. What is a trust? Any type of trust is just a relationship among 3 different parties. You've got the creator, the trustee, and the beneficiary. The creator creates it and puts property into it. The trustee manages that property for the beneficiary. Now, with a revocable trust, you are serving in every role. And think of it as like a bucket. You create this bucket, you put property into it, and you, as the trustee, manage that property for yourself while you're alive. So for all intents and purposes, with a revocable trust, you're doing the same thing that you're doing now. I'm sure everyone on the call owns property, and you manage it for yourself. With a revocable trust, you're just doing it in a different form. Excuse me. So let's say this time, Brian, if we can go to the next slide. Let's say this time you plan with a revocable trust. And we have your bank accounts, your investment accounts titled in the name of the trust. So you're not managing them as an individual, but as a trustee. Bear in mind, you still have full control. It's revocable, it's changeable. You can put property in, you can take property out. But once property's in there, you own it as a trustee. And the trust document says that if you are determined incapacitated, then you are removed as a trustee, and someone else, like your spouse or a friend, steps in as successor trustee to use that property for you. So same example, your mind starts to go and you're giving money away to anyone who calls. your family has you declared incapacitated, and per the terms of the trust document, you are removed as a trustee. The key here is that your bank accounts, your investment accounts are still in trust, but you're not a trustee anymore. And because you're not a trustee, you can't touch those accounts anymore. So it's far less likely that we're going to have to go to court and have a judge strip you of your rights to that money. We should not have to go to court. So that's how planning with a revocable trust can be better incapacity planning. So let's move on to healthcare. The first document you're going to need is called a healthcare power of attorney, healthcare POA. It authorizes someone to be able to make decisions for you, like choosing doctors, hospitals, treatments, and so forth. It applies to both end of life and before end of life. Before end of life, like you might not be on your deathbed, but you're in a coma for a few days, or you've got Alzheimer's. It also applies to end of life. As far as end of life goes, that's you telling your family the kind of treatment that you want. Now, the second document is called a living will, and that is you telling the doctor what you want regarding end of life treatment. I also like to include a separate HIPAA waiver. Now, there is HIPAA language built into the healthcare power of attorney, but I think it's important to include a separate HIPAA waiver. And many attorneys don't do this, and I'm not sure why, but here's why it's a really good idea to have one. Say excuse me, the example I often give is, say you pass away related to something like medical malpractice, and your family wants to sue on your behalf. Well, they're going to have to gather your protected healthcare information. And like I just said, there is HIPAA language in your healthcare power of attorney, but when you pass away, your healthcare POA terminates. So your family cannot rely on your healthcare POA anymore to gather your protected healthcare information. The HIPAA waiver lasts for up to 2 years after you pass away. So through that HIPAA waiver, they should be able to easily access that protected information. And now I'll let Brian speak about long-term care insurance.
Yeah, it's if we're going to talk about incapacity, we got to talk about long-term care planning, right? And so one of the things that we ask all of our folks here that we work with is, what are you doing to fund for long-term care? What we've seen, there's been a lot of changes in the industry here recently. Your traditional long-term care policies typically have you pay a premium into it. Your traditional policies actually, that premium tends to go up, and it can move depending on that, so you don't really know what you're paying into it. And then, if you never need it or you don't use it, there's nothing for your heirs. So you've paid into this policy that you may never need. And I think that's one of the reasons why a lot of people don't do it. The industry has changed a lot. And so now they're doing different types of life insurance with long-term care riders. And the benefit of that is, you know what you're going to pay. You're paying into something at the level premium. There's also a cash value you're building and a death benefit. So, if you never use it, at least your heirs, you can, part of your estate plan, they will be able to also benefit from that as well. And the other thing too is that there's, some of these plans, if you've got a long-term care plan, one of the things that we look at is what actually triggers it, right? So sometimes it'll only cover certain things, okay? Whereas we try to focus on plans that simply triggers when you are unable to perform 2 of the 6 what we call activities of daily living. And when it triggers that, then it covers anything. Like if you want to, if you need to put in a ramp in your house for a wheelchair, or you need to go into a facility or whatever, it's there. Where a lot of other plans are like, well, we're only going to cover a facility or a nurse or this or that. So, there's things you want to look at in there. But if you have a long-term care policy, maybe you got it a while ago, it's probably a good time to get it reviewed. If you don't have anything like this and would like to see, that's something we can also look at for you as well. Okay. All right.
Sometimes I hear people say, Justin, if I ever have an estate, I'll come see you to do estate planning. Or people think it's only for the wealthy. But as we've already talked about, and we haven't even touched on death yet, estate planning affects everyone. We don't know when you're going to die. We don't know if you're going to become incapacitated. We had a couple years ago, we had a single woman years ago, about 30 years old. She was in a car wreck, and as a result, in a coma. And with medical bills racking up, through her employer, she had a disability insurance policy in place. But her family could not trigger it to pay out because they didn't have the authority to. She had not done any planning. So that, again, they have to go to court. I say this over and over again. They had to go to court, spend a bunch of time and money to get the authority to be able to do that stuff. A simple plan would have solved that. So estate planning affects everyone. I hope you're all having fun. Stage 2, death. The death rate's 100%. It's going to happen to us all at some point. You could die today, or you could die when you're 100. We don't know. So how will your assets be transferred to your loved ones? You have two options: to use either a will or a revocable trust. Now, there's a big misconception out there that if you plan with a will, that's going to help you avoid probate court, but that's not true. A will is just your instructions to probate court about who gets your stuff. Now, there are some exceptions. Assets that have a beneficiary form attached to them, like life insurance policies, retirement plans, as long as you have named a person on there, you pass away, that asset goes outside of probate court and straight to that person. So not everything goes through probate court, but you're still probably going to have certain things that have to go through probate court. And in this context, probate court is just a court supervised process where they're overseeing the transfer of the assets from you to the people stated in your will who are supposed to get those. Now, why do some people wish to bypass probate court? One, is time consuming. In South Carolina, I'd say on average 12 to 15 months. It's possible to do it in less time, but that's a good average range. There are court fees involved. And for some people, a big concern is lack of privacy. Now, once your will is filed with probate court, it becomes public information. So a stranger off the street can pull a copy of it, see what it says. Many people are concerned about that. And finally, I'll just say one last thing. You're on the court schedule. Your family's dealing with the government. So the alternative is to plan with, as we've already discussed, a revocable trust. And again, a revocable trust is a trust that you create for yourself, and you as the trustee manage that property for yourself as the beneficiary. How does it bypass probate court? Again, once your assets are in trust, you own those assets as a trustee. The trust document names a successor trustee to step in and take title to that property when you pass away and distributes the property based on what the trust says. That's technically how it bypasses probate court. I think an easier way to understand how it gets around probate is, let's say you pass away and you own stuff in your individual name. We got to probate it. Instead, if the assets are in trust, you pass away, the trust never really dies. It just continues on. Stories, I've already told one story. Stories tend to have perhaps the biggest impact on getting people to plan. Oftentimes, it's not until something happens to your brother or your dad that prompts people to do something. We've already told some stories, and here's one more to, again, emphasize the importance of getting something in place. It's been my experience that spouses tend to think that, I die, my wife is just going to get my stuff. But that's not necessarily true. If you don't have a plan, in South Carolina, the will that South Carolina writes for you says that of your separate property, if you're married with kids, your spouse gets half of that and your kids get the other half. So the story is, a few years ago, husband and wife owned a house, half and half. Wife passed away without a will. Now, she had a son from a previous relationship. Of wife's one half, husband got half of that, and her son got the other half. So bottom line, stepdad ended up owning 3/4 of his own house, and stepson owned 1/4. Stepdad had to buy out son's 1/4, excuse me, 1/4 to the tune of about $50,000. And stepdad's like, Justin, I just thought it would come to me. And so the moral of the story is get a plan in place. Final stage, how are you going to leave your stuff to your kids? You have two options, either outright or in what's called a testamentary trust. Now, if you leave your assets to your loved ones, your spouse, your kids, other people, if you leave it to them outright, once they inherit it, it's more exposed to being taken from them through divorce, bankruptcy, car wrecks. We can brainstorm all kinds of scenarios. Now, to avoid this, we can use what's called a testamentary trust. What is a testamentary trust? It's just a trust that you create for someone else. In contrast, a revocable trust, that's a trust you create for yourself. If you create a trust for someone else, once money and property is in there, it's very protected. So you're the creator, you put property into it at your death. Let's say that your child is the beneficiary. If you think your child is old enough, financially mature enough, the child can be the trustee of their own trust and still have heavy protection of their inheritance. So let's use me as an example. I use myself a lot. Brian, if we can go to the next slide. Let's say that my parents' plan says that when they pass away, I get my inheritance outright. So I get it outright. 8 years go by. My wife wants a divorce. Maybe she ends up taking a significant portion of my inheritance in that divorce. Or I cause some horrific car accident. I don't have enough insurance coverage. Maybe all of my inheritance is taken from me. Or us lawyers get sued. Sometimes got to pick on us lawyers. I've got insurance in place, but what if it's not enough? Bottom line, it's more exposed to being taken from me. So the way I've designed my own parents' plan is they pass away, assets come to me in a testamentary trust. I'm the trustee of the trust. If I need to make mortgage payments, I, as the trustee, cut the check to the bank. If I need to pay for doctor bills, vacation expenses, whatever, I, as the trustee, cut the check to that third party. Then I get divorced, sued, whatever. The money and property that's still in trust is very protected. So those are the 3 stages of estate planning. Incapacity, for financial and miscellaneous matters, you're going to plan with either a will or a revocable trust. For healthcare decisions, healthcare matters, healthcare POA, living will, and a HIPAA waiver. For death, you're going to use either a will or a revocable trust. And for asset distribution, you're going to leave your stuff either to your beneficiaries outright or in a testamentary trust. And now back to Brian for some updates.
Thanks, Justin. Going to take the next couple minutes here and just talk about a few updates. One of them being, by the way, let me just say there is a Q&A. I know, Sandra, you just asked a question here. We'll get to it here in just a couple minutes. If you have a question or you're thinking about something, go ahead and just type it into the Q&A piece, and we will spend as much time as you need here at the end answering your questions. So you can pop them in right now if you have them. All right, Secure Act, right? This was passed here at the end of 2019, and it really changed some things when it comes to planning. One of the things it changed, of course, it raised the age of required minimum distributions from 70, the year you turn 70 and a half, to 72. So you can delay having to take money out of your IRA account. It also eliminated the age restriction, right? People are working a lot longer now, so they want to continue to maybe fund some of these retirement accounts. Well, they can. There's no more age restriction anymore. But the biggest change, and what really affects on the estate planning side, was this idea of a stretch IRA, okay? Where in the past, you have an IRA, you have your beneficiaries on there, you pass, they get your IRA, well, then they would have to start taking money out of that IRA based on their life expectancy. So if your beneficiary was, let's say, a 30-year-old and their life expectancy was to age 85, well, then they could take money out of that IRA based on a 55-year schedule, okay? Well, now the government eliminated that. And so IRAs now, you have a 10-year period to distribute that IRA out, no matter what age that person is. So there's definitely some changes there, things that I know we've been reviewing with a lot of our clients, and something that you're going to want to take a look at as well, okay? Two things here on IRA Tech Strategies that we want to go ahead and run over. I know this is estate planning, but you have an estate, right? It's got assets and things like that, so we wanted to add a couple things in here on that. First thing is, one of the things that we're talking with a lot of folks right now about are IRA Roth conversions, okay? And here's the reason. Taxes are on sale. Taxes right now are some of the lowest they have ever been. So if you want to pay taxes on something, which at some point you will have to, now is a good time to do it. Our belief, and it may be yours or not, but with all of the government spending over the past few months that we've seen, we think over the next 5, 10, 15 years, taxes are probably going to be trending higher to help pay for some of this stuff. So right now is a good time to look at IRA conversions. And then also qualified charitable distributions. This is something that a lot of people don't realize about. If you have an IRA, or especially if you're taking your required minimum distribution right now, actually using that for a qualified charitable distribution, because it lowers your adjusted gross income. There's some benefits there. You know, we tell folks a lot of times they'll have a charity named in their will, and they say, well, you know, I want this much to go to this charity. And we say, well, why wait till then? Why not, you know, maybe there's some ways we can go ahead and take that out and do this now, and it can be a tax benefit to you. So just something there that we also look at as well. And then finally, the incapacity issues, especially that we've been talking about, that Justin was talking about earlier. COVID-19's changed some significant things on that. One thing that you're going to want to look at, especially with your living will, is you want to review your ventilator decision. I would say, you know, going on a ventilator, you know, it's always kind of a last resort thing. You know, people, you know, they may want to be kept alive. They may not want to be kept alive by artificial means. You know, ventilators have saved some lives here. So that might be something, you know, in light of coronavirus, that you may want to take a look at or review there as well. Also, your healthcare power of attorney. You know, you want to make sure that there is wording in there, and there's things in there that whoever that person is can act on your behalf virtually. Normally, you have that power of attorney as someone that lives near you. They can be there in person. Obviously, that's not necessarily the case anymore. And then lastly, are your documents digitized? Okay, so if you have to go in the hospital and you have a healthcare power of attorney, but it's sitting at home in a file cabinet somewhere, you know, even if your loved one can get over there and get that piece of paper, they still have to now go to the hospital. They can't be with you. They have to give it to someone, things like that, where now you want to make sure that all your stuff is also organized, not only physically, but digitally as well, so you can very easily send these things to folks there. Which, you know, again, what we're talking about here, get organized, be organized, okay? Because the more organized you are when bad things happen, the easier it is on you and your family. So as we talk about planning, we talk about being organized. You know, it's one thing to have a will, revocable trust, other documents, but if your family doesn't know what you own, if your family doesn't know what you have, it can be a big problem. We don't like to have these conversations, right? Because, you know, we're talking about our death. But if your family doesn't know where these things are, it does create a lot of distress, okay?
Brian, if you can back up one slide.
Sure.
I'd just like to add one, just piggybacking on what you said, Brian. It's not knowing what you own, it's also knowing where your documents are. Far too often, the kids come to me and they can't find their parents' estate documents. So let your kids, let the people involved know where your documents are. And I also like to say, the more disorganized you are, the more people like me tend to get paid. So against my own economic interest, you know, be organized.
Right. I love it. I love it. All right. And then finally, do something. All right. And here's one of the things that you can do as a first step here. Okay. We are offering a 30-minute complimentary estate plan checkup. Okay. And Justin and I are basically going to give our time to you for registering for this webinar for complimentary for 30 minutes, where we're going to talk to you about whatever is specific to you or on your mind, answer any questions you have, and just give you our advice, okay? Right now, this week, and actually starting this afternoon, so if you're free this afternoon, we're around. If you go to this link right here, it's just calendly.com/estate checkup. I'm gonna type this here into the chat box, and all you have to do is click on it. And if you go to this link, you'll be able to schedule a meeting with Justin and I. All right, I think I just put it in there. All right, well, it's in the chat box. Unfortunately, it didn't, it wasn't hyperlinked. So let me try this one more time. There we go. Click on it, and we've got time available this week. If you can't meet this week, that's fine. Shoot us an email. We'll try to figure something down the road. But we have set aside certain blocks of time this week. You can just click on it, and we can meet with you. There's no obligation. We're not selling anything. We're just here. We're making ourselves available to you, okay? Again, just as it says in the slide here, for best results, and we're firm believers, you want to surround yourself with a team of trusted advisors, okay? And the reason why Justin and I work together, he handles the legal part of things, the drawing up the documents, and I kind of serve a little bit, as the quarterback. We're looking at your financial assets, because essentially that's what we're trying to make sure, but making sure that those things are also doing what they need to do for you as well, and that it all ties in together, okay? All right.
One final story, just to emphasize the importance of getting a plan in place. Years ago, I had a matter where a husband had a will, but he never signed it. So he didn't have a will. You actually have to sign it, and there are other formalities that you have to follow for your will to be valid. So all really husband had was pieces of paper, but he thought he had a will. He thought he had everything in place. And that probate matter, it took about 3.5 years. So get a plan in place. And I like to say that estate planning is the procrastination area of law. The procrastination area of law. If you get sued, that's something that you got to deal with ASAP. With estate planning or financial planning, with any kind of planning, you can always just put it off and put it off and put it off. And then something bad happens and you don't have your plan in place. So we're all guilty of this to some extent. It's really easy to put it off. So I encourage you, final thoughts, just to fight against that tendency and get something in place. Thank you so much. And I think we're going to do some Q&A now. I'll turn it back over to you, Brian.
Thanks so much. Here's Justin's and my contact information, also email address here. And again, here's the link if you want to take advantage of the 30-minute estate checkup. All right, so let's go ahead and get into some questions. So I've got a few here already. And all right, so Barbara Smith's asked a couple times here, can we get a copy of the recording? Yes, this is being recorded, and we will have this available to you. Okay, we'll send a link out or something along those lines where you can get it. All right. Sandra asks, and I think this is directly to you, Justin, says, my husband has an adult daughter who he didn't raise. He didn't even know about her until after she was an adult. If my husband dies with no will, could she have any rights to his property?
Sandra, yes, she can.
There you go. All right, here's another question. Can a revocable trust be changed to the other trust you mentioned? At which stage?
Yeah, so again, for the person who asked this question, you're either going to plan while you're alive with a revocable trust or a will. And that document at your death will create a testamentary trust. So it's not like having a testamentary trust now. You're either going to have a will or a revocable trust at your death. If you plan with a testament, if you plan for that document to create a testamentary trust, it will do so not until your death.
All right. Jan asks, what is the tax impact of naming a testamentary trust as beneficiary to an IRA related to age of beneficiary and being forced to take all out over 10 years?
Jan, that question I'm going to put aside for now. I'm happy to answer it on the phone with you. That's going to take so much time to answer. In general now, as you stated, except for a spouse, in general, a beneficiary has to take it out over 10 years. There are some other exceptions, but it's going to take too much time to answer that question. So perhaps we can schedule a phone call to discuss that.
Yeah, Jan, just if you want to click on that link and click on there, it's just a video call just like this, and we'll be happy to talk through.
Yeah, phone call or video call.
Yeah. Kathy asks, can you set up a revocable trust and set up testamentary trust within that for individuals in your family?
Kathy, correct. Just as I stated in the question, I think 2 questions ago, yeah, so your revocable trust can create that testamentary trust.
Yeah. Diana asks, do you have someone who speaks Spanish? We do have folks here at Parallel that if you do need, if we need an interpreter, we can provide that. So if it's something, Diana.
I'm sorry, Brian.
Go ahead, Justin. Go ahead.
I was going to say, Diana, I actually have someone in my office that can translate as well.
All right. Barbara asks, do you only handle South Carolina?
Yes, Barbara. I can only do planning for people who are residents of South Carolina. But I do have an attorney in my building who is licensed in North Carolina, so she often helps me.
Here's a question that I've got a few questions that people had emailed in earlier who reached out to before the thing, and I know one question was, what if if your documents were done in another state and now you've moved to South Carolina and you live here? Is that something that likely needs to be reviewed?
I would highly encourage that person, Brian, to have those reviewed. It is possible. Well, let's say you have your documents done in New York and you move here and you pass away with a New York will. South Carolina will honor that New York will. However, especially on the incapacity side with your general POA, healthcare POA, I can't say how a third party in South Carolina would deal with that. But bottom line, have all your documents reviewed anyway.
Awesome. All right. Jan asks, if you have a revocable trust, how do assets transfer to your beneficiary that are not detailed in the trust? So like maybe things like a car or a boat or things like that aren't named in the trust, how would those transfer to your beneficiary?
Okay.
Did you get that?
Yeah, so, well, Jan, one way that you can transfer personal property and tangible personal property, it's mostly handheld stuff, but like motor vehicles are included, like cars, boats. We provide you with what's called a personal property memorandum, where you can actually take a pen and at any point in the future, you can write in, my boat to Justin Hamrick. Later on, if you don't want me to get it, you can cross through my name and write the new person in, and that is legally binding.
All right. I think I had one more here. Okay. This was a question that came in earlier. It said, my brother told me I could avoid probate by adding my child to my bank account and house. Is that a good way to plan?
I would highly caution that person to plan that way. A number of problems can go wrong. Let's say that you have 3 kids and you put child 1 on your bank account. You pass away, your bank account will automatically go to child 1 when you pass. It won't go in equal shares to child, child 1, 2, and 3. Now, child 1 might do the right thing and just share it with his or her siblings. But what often happens is child one might be the child that takes care of you later in life, and then you pass away, they get that money, and they think to themselves, hey, I'm the one who took care of mom later in life. I'm the one who spent the most time with her. I'm going to keep that money for myself. Or if you add your child to your bank account, what if your child gets sued? Is your bank account now exposed to their creditors? So I call this probate avoidance gymnastics. People try to do these tricks and jump through hoops, and like in order to bypass probate court through more inexpensive means. But what they often do is they end up creating more problems.
Okay. All right. Well, right now that finishes our questions. If anyone else has any other questions and you want to ask real quick, you can. Otherwise, we are going to go ahead and close this out. So thanks again. Just reminding you, if you want to talk specifically more about your situation, again, Justin and I are offering our time. It's no obligation. Just go to this link, calendly.com, Estate Checkup, and you can click it there in the chat box. And thanks again. Have a great rest of your week.
Thank you.